Legal concepts of an insurance policy. General law of contracts. The, a contract is an agreement enforced by a law. It is the means by which one or more parties bind themselves to certain promises. With life insurance contracts, the insurance binds itself to pay a certain sum upon the death of the insured. In exchange, the policy owner pays premiums. The voluntary act of terminating an insurance contract is called cancellation. General laws of contract. Offer and acceptance. A contract agreement involves a meeting of the minds. To be legally enforceable, a contract must be made with a definite, unqualified proposal offer by one party and the acceptance of its exact terms by the other. In many cases, the offer of an insurance contract is made by the applicant when the applicant is submitted with the initial premium. The insurance company accepts the offer when it issues the policy as applied for. When an offer is answered by a counter offer, the first offer is void. Consideration. For a contract to be enforceable, the promise or promises it contains must be supported by consideration. Consideration can be defined as the value given in exchange for the promises sought. In an insurance contract, considerations is given by the application in exchange for the insurer's promise to pay benefits. It also consists of the applications and the initial premiums. This is why the offer and acceptance of an insurance contract are not complete until the insurer receives the application and the first premium. The consideration clause also contains information such as the schedule and amount of premium payments. Legal purpose. To be legal, a contract must have a legal purpose. The means that the object of the contract and the reason the parties enter into the agreement must be legal. A contract in which one party agrees to commit murder for money would be unenforceable in courts because the object or purpose of the contract is not legal. General law of contract. Insurance contracts are always considered to be pose as legal purpose. Contentment parties to be enforced, a contract must be entered into the contentment parties with a contract of insurance. The party to the contracts are the applicants and the insurer. The insurer is considered competent if it has been licensed or authorized by the states in which it conducts business. The applicant, unless proven otherwise, is presumed to be competent with three possible exceptions: minors, the mentally infirm, those under the influence of alcohol or narcotics. Each state has its own law governing legality of minors and the mentally informed entering into contracts of insurance. These laws are based on principles that some parties are not capable of understanding the contract they agree to. Special features of insurance contract. The elements just discussed must be contained in every contract for it to be enforced by law. In addition to these, insurance contracts have discussing characteristics that set them apart from many other legally binding agreements. Some of these characteristics are unique to insurance contracts. Let's review these distinctions. Aleatory. Insurance contracts are aleatory. This means there is an element of chance and potential for unequal exchange of value, or a consideration for both parties. An aleatory contract is considered upon the occurrence of an event. Consequently, the benefits provided by an insurance company may or may not exceed the premiums paid. For example, an individual who has a disability insurance policy will collect the benefits if she becomes disabled. However, if no disability strikes, benefits are not paid. Both insurance and gambling contracts are typically considered already contracts. Adhesion. Insurance contracts are contracts of adhesion. This means that the contract has been prepared by one party, the insurance company, with no negotiation between the applicant and insurer. In effect, the applicant adheres to the terms of the contract on a take it or leave it basis. When accepted, any confusing language in a contract of adhesion would be intercepted in favor of the insured. The purpose is to correct any advantages that may result from the party who prepared the contract. A policy of adhesion can also be described as one which the insurance company can modify. Special features of insurance contracts. Unilateral. Insurance contracts are unilateral. This means the only one party, the insurer, makes any kind of enforced promise. Insurers promise to pay benefits upon the occurrence of a specific event such as death or disability. The applicant makes no such promise. In fact, the applicant does not even promise to pay premiums. The insurer cannot require the premiums to be paid. Of course, the insurer has the right to cancel the contract if premiums are not paid. Personal contract. Life insurance is a personal contract or personal agreement between the insurer and the insured. The owner of the policy has no bearing on the risk the insurer has assumed. For this reason, people who buy life insurance are called policy owners rather than policy holders. Policy owners actually own their policy and can give them away if they wish. This transfer of ownership is known as assignment. To assign a policy to a policy owner is a simple notification that the insurer in the writing, the company will then accept the validation of transfer without question. The new owner is granted all the rights of the policy ownership. Conditional. An insurance contract is conditional. This means that the insurance promise to pay benefits depends on the occurrence of an event covered by the contract. If the event does not materialize, no benefits are paid. Furthermore, the insurer obligations under the contract are conditioned on the performance of certain acts by the insured or the beneficiary. For example, the timely payment of a premium is considered for keeping the contract in force. If premiums are not paid, the company is relieved of its obligation to pay death benefits. Value of indemnity. An insurance contract is either valid contract or an indemnity contract. A value contract pays a stated sum regardless of the actual loss incurred. Life insurance contracts are value contracts if an individual acquires a life insurance policy insuring her life for $500,000 in the amount payable at death. There is no attempt to value actual financial losses upon personal death. An indemnity contract, however, is one that pays an amount equal to the loss. Contracts of indemnity attempt to return the insured to the original financial position. Fire and health insurance policies, for example, of indemnity contracts, an insured that owns a $500,000 fire insurance policy and suffers a $5,000 loss due to fire will be able to collect up to $5,000, not $50,000. Insurance, utmost good faith. Insurance is a contract of utmost good faith. This means both policy owner and insurer must know all materials, in fact, and relevant information. There can be no attempt to, by either party, conceal, disguise, or deceive a consumer purchasing a policy based largely on the insurer and agent explanation of policy benefits and advantages. Insurance applications are required to make full, fair, and honest disclosures of the risk to the agent and insurer. Concept related to the utmost good faith includes warranties, representations, and concealment. These represent grounds through which an insurer might seek to avoid payment under contract. A warranty is an insurance statement made by the applicant that is guaranteed to be true in every respect. It becomes part of the contract, and if it's found to be untrue, can be grounds to revoke the contract. Warranties are presumed to be materials because they affect the insurance decision to accept or reject the application. Representation. A representation is a statement made by the applicant that they are considered to be and are accurate to the best of the applicant's belief. It is used by the insurer to evaluate whether or not to issue a policy. Unlike warranties, representations are not a part of the contract and need to be truly only to be extent in that they are material and related to the risk. Statements made by the applicants for insurance are considered to be representations and not warranties. A false statement made by an applicant that would influence an insurer in determining whether or not to accept the risk is considered material misrepresentation. Concealment. The issue of concealment is also important to insurance contracts. Concealment is defined as failure by application to disclose known materials, in fact implying in material fact when applying for insurance. If the purpose for concealing information is to defraud the insurer, that is to obtain a policy that might not be otherwise be issued if the information were revealed, the insurer may have grounds for voiding the policy. Again, the insurer must prove concealment and maturity. In most cases, life insurers have only a limited period of time to uncover failed warranties, mispresentations, or concealments. After that time period passes, normally 2 years from the policy issue, the contract cannot be voided or revoked for those reasons. Insurable interest. Another element of valid insurance contract is insurable interest. Insurable interest is a component of legal purpose. This means that the person acquiring the contract, the applicant, must be subject to loss upon death, illness, or disability of a person being insured. To have an insurable interest in the life of another person, an individual must have a reasonable expectation of benefiting from the other person's continued life. A policy obtained by a person not having an insurable interest is that the insured is not valid and cannot be enforced. Thus, insurable insurable interest must exist between the applicant and the individual being insured. When the applicant is the same as the person to be insured, there is no question that the insurable interest exists. Individuals are presumed to have insurable interest in themselves. It is important to note that insurable interest must only exist at the time of the application of life or health insurance contract. It doesn't have continuing thought duration of policy, nor it has existence of time of claim. Stranger orientation life insurance, STOLI. Stranger oriented life insurance, STOLI. Translations are life insurance arrangements where investors persuade individuals, typically seniors, to take out new life insurance, naming the investor as the beneficiary. This is sometimes called investor-oriented life insurance. IOLI. These arrangements are used in circumvent state insurable interest status. Generally, the invested loan is money to the insured to pay the premium for a defined period, usually 2 years, based on the life insurance policy period.